Good evening, everyone. My name is Tabanya. To our colleagues who has been following my TikTok account, YouTube channel, and my Facebook page, I'm a lawyer who does different courses. And in this episode, I'm going to conclude the law of contract with the remedies that are in contract. Last time when I posted a video, I was talking about vitiating factors, and I concluded vitiating factors. Now, what are the remedies in contract? So the remedies in contract, the aim is to put the injured party in the position they would have been if the contract had been properly formed. Remember, on my previous videos, we were talking about vitiating factors, and I said vitiating factors can render the contract void or voidable, and we mentioned different types of vitiating factors. We discussed duress, undue influence, mispresentation, and other types of vitiating factors. Now, when that occurs, does the injured party goes freely? Now, that's the question. So, on this episode, we are going to discuss the remedies that are there, more especially to the injured parties. So, one remedy which is here, of course, it is the damages. Now, the damages, they are not just general damages. Damages, there are different types of damages. It can be punitive damages, compensatory damages, or normative damages. So when you talk about punitive damages, they actually aim at punishing the other party who made the other party who entered in the contract with to suffer the damages. So this punitive damage, it only aims to punish that other party. Compensatory damage. So about compensatory damage, we are talking about compensating someone, the injured party. We are compensating the injured party. So most of the time, it is in terms of monetary forms. One thing that I forgot to mention is there is liquidated and unliquidated damages. When you say liquidated, it means the damages they can be quantified, and unliquidated damages they cannot be quantified. So actually, so damages we've talked about punitive that aims at punishing the offender. The other one which is compensatory damage, and actually we have I've given you an example. The normative damages, these are just small claims damages that are there. So the other remedies in contract, maybe there is a breach, more especially when there is a breach of the contract, is an injunction. What is an injunction? I think this is a familiar term that is used in an injunction. So an injunction can be used as a remedy to stop someone or to refrain someone from doing the things. So there can be where a party to a contract has breached the terms of the contract. The court can actually put an order for that person to actually refrain from doing more. The other one, it is actually specific performance. So there are two people who entered in a contract. Yes, we know that each party adds an obligation that must be satisfied in that contract. And in the case whereby the other party has failed to actually deliver or its obligation, the court can actually order specific performance so that other party can actually do the side of the bargain. The other remedy that is there, it is rescission. Rescission, it actually sets the party in the way they were before they entered in a contract. So it is actually there just to put the injured party in the way they were before the contract. In a simple terms, rescission, it is setting aside the contract. So we have mentioned a few remedies that are here, starting from damages, which I mentioned that there are types of damages. It can be punitive, compensatory, normative, and other damages that I have not mentioned. The other remedies, which is an injunction, which is an order from the court to the party to refrain from doing something, and then a specific performance, the other party to actually do its part of the bargain, and rescission to setting aside the contract. So thank you guys. So that's what I add in the law of contract. You can follow my TikTok account, subscribe to my YouTube channel, and follow my Facebook page. So just comment in the comment section which other course we can start. If it's not evidence law, then we can start civil and criminal procedure, more especially in terms of drafting. Thank you.